All right, cool. Let's get this started. So, welcome everyone. Thanks for joining. This is our first ever Q&A session hosted by Trowbridge Law Group. I guess the idea behind this was to kind of do like a Ask Me Anything, like a AMA, so that people who follow us online have questions about securities or syndication or crowdfunding. You could ask me anything you want. It doesn't even have to be about crowdfunding or securities. You could ask me random questions, and if I don't know the answer, I'll tell you, and I'll try to give you my best advice on where to find those answers. But anyways, quick introduction. My name is Jon Nieh. I'm one of the founding partners here at Trowbridge Law Group. We specialize in real estate syndications, but really what we do, we're securities attorneys. So what that means is anytime you're raising money, you are probably selling securities, and there's a bunch of SEC, Securities Exchange Commission rules that you have to follow. So we kind of guide our clients on those rules and make sure that they're raising money legally. So even though most of our clients are real estate syndicators, we do have clients that are doing things, raising money for things besides real estate. So I've had clients that raise money to do like a distillery or to open a boba shop. We've had clients that were doing an olive farm or buying and selling racing horses. So I mean, it really doesn't matter what you're doing. If you're raising money, you're selling securities, and you need a securities attorney like us to handle the compliance issues. I've been doing this for about 8 years now. I graduated UCLA School of Law in 2016. In that time period, I think I've represented over 100 clients. Our firm, though, collectively, we've helped clients raise over $6 billion. So pretty good sum. What else did you know about me? I'm actually based in California, but I'm licensed to practice law in California and Texas. The reason why I got my license in Texas was we have a lot of clients in Texas that syndicate deals in Texas, and it would be beneficial to them if I could, handle some of the Texas specific issues that they face. A couple of housekeeping things. So this session is recorded, so you don't have to worry about that. You'll get a recording of this once it's done. If you have questions, put them in the chat. I believe that's the only way you can ask me a question right now, unless you submitted questions before. I will answer all of those questions that came in through email, and I will do my best to answer all the questions that come into the chat today. Hopefully, I have time to answer all of them. We got about an hour. If I don't have time, what we could do is just do another one of these sessions at a future date. But with that being said, we thought it might be a good idea to have kind of a overview of syndications and securities laws to kind of set the stage for everyone, to make sure that we're all kind of on the same page as far as the basics that you have to know. And then once I go over that overview, then I'll get into the actual questions. So let me share a slide with you guys. So question is, what is a syndication? Well, this picture is kind of here to kind of illustrate that, or to kind of answer that question for you. So if you invest in real estate, at some point you're going to learn or read, or someone's going to tell you that you really should use some sort of entity to hold your assets, to hold the properties that you own. And the most common entity that people use is an LLC. And the reason for that is an LLC is a limited liability company, and through its name, it kind of implies that it has limited liability, right? So using an LLC is a way to protect your personal assets from business creditors, right? So that's the main reason why you want to use an LLC. There's also tax advantages of using an LLC as well, but I'm not a tax attorney, I'm not a CPA, so if you have questions about tax issues, definitely talk to your own CPA, talk to a tax attorney about that. But anyways, so if you invest in real estate, you're probably using an LLC, and this is generally what the org chart or the org structure is going to look like, right? So you have what we call the investment LLC, but it's the LLC that actually owns the property. And you owned the LLC. You are the owner of the LLC that owns the property. Well, LLC owners of the LLC, they're called members, right? So in a partnership, it's the partners that own the partnership. Well, in an LLC, it's the members that own the LLC. And through your membership interest, you first you buy membership interest in the LLC, and through that you receive distributions from the property. So property cash flows, cash gets paid to the LLC, and the LLC pays you, the member of the LLC. Well, at some point, when you're investing in real estate, there's going to be a deal that comes across your desk that you don't have enough capital on your own to do. So what do? Well, one of the options you have is syndicating, right? Syndicating a deal is raising money from investors, collecting investor funds together to invest in real estate. This is basically what a typical syndicated deal looks like. This is the typical org structure for a syndicated deal, right? So same thing as, if you're doing it on your own, where you have an investment LLC that owns the property, but instead of just a single member, you have multiple members, right? So all of your investors that are going into the deal with you become members along with you. However, there is a very big difference in the fact that there is now usually a managing entity, right? Because you're, if you're syndicating the deal, you're probably setting it up so that you, the syndicator or the sponsor, have some sort of control over the deal, right? So, you're the one that's setting up the deal. You're the one that probably found the deal. You probably have more experience, more knowledge than the other investors. So you're the one that should be in control and making the decisions about the deal, about the property. Well, if that's the case, then you need some sort of management entity, which is the manager LLC in that orange box. So how it's set up is, members contribute capital to the investment LLC. So they invest in the investment LLC, and they receive distributions from the property through the investment LLC based on their ownership. And then you own the manager LLC, which manages the investment LLC. And because of that arrangement, you also receive cash from the property through the investment LLC, and you also receive fees, right? So that's how your fee structure is kind of legally structured through this management LLC that manages the investment LLC. So if you're familiar with limited partnerships, right, LPs and GPs, the investment LLC is essentially the LP, right, the limited partnership entity, and the manager LLC is essentially the GP, the general partnership entity. And in fact, in our industry, that's kind of used, those terms LP and GP are used interchangeably, even when it's an LLC. So you'll hear a sponsor say, hey, we have GPs involved, we're the GP, we're part of the GP team. But when you actually read the documents, it's, an LLC, and it's the manager LLC that they're really referring to. The box on the bottom, enhancers, that's other people kind of involved in the deal that might not necessarily be ownership or have ownership interest in the investment LLC or the manager LLC. So for different reasons, you might need to bring outside people into the deal, right? So some examples are creditworthiness, liquidity. So if you're getting a loan from a lender and your credit isn't good enough to qualify for the loan, you're gonna have to bring in another person that has better credit, right, to bring your collective credit to meet their underwriting threshold, right? Same with liquidity. Lenders typically they need the sponsors to have a collective net worth that equals the value of the loan. If you don't have that enough on your own, you're gonna have to bring in co-sponsors, or the term they used in in the industry is key principals, right? So KPs or key principals, that's who you're gonna have to bring in. And then you also might need help raising money. If maybe you don't have a big enough network of investors to reach out to, you're gonna have to, find co-sponsors and add your networks together of investors. And then the last example is, property management purposes. If you don't have any experience managing deals before, so you never, you never invested in real estate on your own, you're probably going to have to hire some sort of third-party property management company. But anyways, this is what a syndication is, right? So it's an investment of money in an LLC for the purpose of realizing profits, right? The distributable cash to investors. And it's the fact that there is a manager LLC that is making all the decisions. Well, if that is the case, then you are actually selling securities, right? So the definition of a security, well, not the definition, but how the SEC determines if you are selling a security is they use a test called the Howey test. It's a 4-prong test, right? And if what you're doing meets all 4 factors of that test, all 4 prongs of that test, then the SEC will say that you are selling securities. Well, the 4 prongs are an investment of money in a common enterprise with the expectation of profits solely through the efforts of a promoter, right? And if you look at this picture, that's exactly what is going on. You for sure meet those 4 prongs of the Howey test because investors or the members are contributing money into the investment LLC. That is the common enterprise, is the fact that there's a pooling of investor funds in this single entity for this single purpose. Investors are doing it because they expect the profit, right? They're not investing out of the kindness of their own heart. They're not donating money. They're investing to make a profit, a return on their investment. And the last factor is met because there is a manager LLC that is making all of the decisions on behalf of the investors. You might be asking, okay, what if we don't want to sell securities, right? What if we don't want, to structure our deal so that we're governed by SEC rules? Well, if that is your goal, then my recommendation or my, I don't want to say my advice because I'm not advising you as an attorney. This is just for educational purposes. But if you are syndicating a deal and you're using LLCs, basically the only way to get around that or to defeat one of the prongs of the Howey test is that 4th prong, right? Solely through the efforts of a promoter. If you're setting up the deal as an LLC, there's for sure going to be investment of money. There's going to be a common enterprise, right? Because of the LLC, and your investors expect to make a profit. So there's no way to get out of those first 3 prongs. But how do you get out of the last prong? Solely through the efforts of the promoter. Well, you have to make sure that there are no passive investors in the deal. And to do that is, I should explain, right? So an LLC, you could set it up in 2 different ways, either as member managed or manager managed. So this picture shows a manager managed LLC, right? The investment LLC is managed by a manager. Well, if you set it up as member managed, and this all depends on number one, how you form the LLC with the specific state that you're forming it in. So what it says on the articles of organization, and then number 2, what it says in the operating agreement. So the operating agreement is the governing document for the LLC, and that governs how the LLC is run. So if that operating agreement says this LLC is member managed, and that means that every single member has a say in how the company is run. So they each have decision-making authority. Then you could make the argument to the SEC that 4th prong, solely through the efforts of the promoter, that prong isn't met because there is no promoter. Every single member is making decisions. Well, that is feasible, if you're doing a deal and you only have a few investors, right? So maybe 3 or 4 investors total, and all those investors have a say in how the property is run. That's doable. And in that case, that's not really a syndication, right? Because that's more of like a joint venture. You're entering into a JV agreement with 3 or 4 other investors. What if you're raising money from like 10 or 15 or 20 investors, and now your operating agreement says all 20 investors have to agree on every single decision that happens regarding the property? How are you going to make a decision? You can't, right? So if you're doing something like that, then you definitely or you probably need to set it up as a manager managed LLC, in which case all 4 factors of the Howey test are then met, and you are selling securities. So that being said, if you are selling securities, and here's the 4 prongs of the Howey test. What does that mean, right? What does that mean if you are selling securities? Well, that means you're now in the SEC world, and the general rule, the basic rule that the SEC has is every security that is sold must be registered with the SEC unless exempt. So registration with the SEC is essentially becoming a publicly traded company, right? So when a company does their IPO, they are registering their securities with the SEC for the first time. So you can imagine, if you're syndicating a deal and you're selling securities because you have a manager managed LLC, the rule says that you have to basically do an IPO with the SEC unless you have an exemption. And really, that's what Gene and I, our firm, we specialize in is, these exemptions, navigating these exemptions. So the exemptions that are available are basically what you have in front of you, right? So you have, or not the exemptions available, your options available to you, I should say, are laid out in front of you. So option 1 is to do a full-blown public offering, do an IPO essentially. And you think about the companies that do IPOs, they're billion-dollar corporations, right? And the reason for that is because it costs hundreds of thousands, if not millions of dollars to go through the process. You got to pay attorneys, you got to pay accountants, you got to pay underwriters, and on top of that, it's a long process, right? So it could take years to become public, and then additionally, once you do become public, there's ongoing compliance that you now have to are required to do, right? So yearly reports, yearly audits, quarterly reports, quarterly statements. It's extremely expensive. So if you're syndicating a deal, you definitely don't want to do a full-blown public offering. What are your other options? Well, you could do a small public offering, either under Regulation A or Reg CF. Which I actually did get an email question about Reg CF, so I will talk about that. But does anyone want me to go into depth about Regulation A at all? I'll just assume someone said yes. So Regulation A, yeah. Okay, Michael, thank you. You raised your hand. Okay, Regulation A. It's kind of known as a mini IPO. It's like a small public offering, and the reason for that is, well, unlike a full public offering where there's no limit on how much you could raise, Regulation A has a limit on how much you could raise. Currently, you could raise up to $75 million per year. But the reason why it's known as a mini IPO is the fact that it's public, right? It's essentially public. You could raise money from anyone, so accredited investors and non-accredited investors. It's public so that you can advertise your offering. You could sell your securities to anybody, anywhere, anytime. But some of the drawbacks is, like a full public offering, you probably need to hire some sort of accounting firm to either audit or review your financial statements. That last bullet about being preempted from blue sky requirements, to kind of explain that. So this is going to be a long long-winded answer, but basically there's two tiers under Regulation A. There's tier 1 and tier 2. Tier 1 offerings have a much lower amount that you can raise. So I believe right now it's either 25 or $50 million per year. But if you do a tier 1 offering, you don't have to get audited statements. You could just get reviewed statements, which are cheaper, easier to get from an accounting firm. But the drawback of doing that is you do not preempt blue sky requirements, which means every state that you're raising money from, you have to find a state rule, basically a state-specific rule that allows you to raise money in that state. So you can imagine, doing a tier 1 offering. Yes, you save money not having to get audited financial statements, but in the long run, you're actually probably paying more money in legal fees because there's more legal work you have to do to meet those blue sky filing requirements. If you do a tier 2 offering, which is the higher amount, the $75 million amount, yes, you have to get audited financial statements. But if you do that, then you preempt blue sky requirements, and now you don't have to go to every single state to get approval before you raise money. So I think most people recommend just doing the tier 2 offering, the higher one, right? Because you pay a little bit more upfront with the audited statements. But at the end of the day, you actually save money because you don't have to pay as much in legal costs to do the blue sky filing stuff. So, Reg A sounds great. You can advertise to anyone. It's basically a mini IPO. You can raise money from anyone, so accredited and non-accredited. But why wouldn't you do Reg A? Well, number one, it's time consuming, so it's not as time consuming as doing a full-blown public offering. But from what we've seen, it takes at least 6 months, sometimes up to a year, to get approval from the SEC before you can start raising money. It's also expensive. So legal costs, you're spending at least $50,000 to maybe $100,000 in legal fees, accounting costs as well. And then on top of that, marketing your offering, you have to budget money for the marketing part of it, selling your securities. And then lastly, there is ongoing compliance that you have to go through with the SEC and state securities regulators if you do those blue sky, if you do a tier 1 and are now, required to do blue sky filings. So it's not as intensive as, a full public offering, but it's still a lot of work. It's still expensive. It's still very, very time consuming to do a Reg A. So that's why in our line of work, we typically don't really see too many people do Reg A's because of the fact that it's expensive and it takes a lot of time. If you're doing an offering, if you're syndicating a deal for a specific property, so a property that you already have under contract, then for sure you can't do a Reg A because you don't have the time. If you have to wait 6 months to a year to get approved, there's no way you're going to be able to close in time. So who is Reg A really for? If you're thinking about syndicating and doing Reg A, you're probably doing what's known as a blind pool, which means you don't have a specific property under contract. You're raising money blind to purchase a bunch of future properties, which, people have done this, right? So people have done Reg A's. The people who have done Reg A's are these blind pool syndicators. That's really only about it in the real estate space, at least. But Reg A is one of the only options available if you want to advertise, so general solicitation, and if you want to accept small investors, so non-accredited investors. So that's Reg A. Reg CF, we got an email about Reg CF, so let me answer that question right now. So regulation crowdfunding. And actually, this might be a good point to quickly discuss crowdfunding, what that means, and the difference between that and regulation crowdfunding. So crowdfunding, I think it's a term that's misused a lot I mean, a lot of people kind of use it as like a buzz term, right? So it's more of like a marketing term. People say they're crowdfunding when they're not really actually crowdfunding, legally crowdfunding. But I mean, crowdfunding became a really big deal because of things like Kickstarter, right? Like, Kickstarter, I think 10, 15 years ago, when it was like this new thing, there was a ton of buzz around, raising money online from your fans, basically. And that's essentially what crowdfunding is, raising money from the crowd using the power of the internet. Well, Kickstarter and Indiegogo and GoFundMe, those are great. And those are, easy to raise money on, because if we go back to the definition of a security, companies that are doing Kickstarter campaigns or Indiegogo or GoFundMe campaigns, they're not selling securities, because investors, or not investors, but contributors on a Kickstarter campaign, they're not expecting to make a profit on their investment, right? They are essentially pre-ordering a product on Kickstarter. Same with Indiegogo. GoFundMe is donation based, right? You're donating to a good cause. So there's no investment, there's no expectation of profits. Sorry, excuse me, on those platforms, right? So, crowdfunding, that kind of crowdfunding doesn't require you to register with the SEC. Well, 15 years ago, or actually it's about 11 years ago, 2013 is when Congress passed the Jobs Act, the Jumpstart Our Business Startups Act. And that was kind of passed in this wave of, Kickstarter and Indiegogo and GoFundMe being new and hot and exciting. And a lot of people wanted to crowdfund, but sell securities, right? Do equity crowdfunding. So they pressured Congress to pass the Jobs Act, and part of the Jobs Act was the creation of regulation crowdfunding, which was supposed to be like Kickstarter, but allow companies to raise money, allow companies to sell equity in their company. So regulation crowdfunding, it's been around for about, almost 10 years now. Kind of give you the highlights of it. So number one, it allows advertising. So just like Reg A, just like a full public offering, it allows advertising. You can raise money from accredited and non-accredited investors. So just like Reg A, no restriction on who can invest in your deal. However, unlike Reg A that has a $75 million max, regulation crowdfunding has a $5 million max currently. It used to be a lot less, actually. When it first came about, it was $1 million. And they realized that that was way too low. No one was going to be able to utilize it. So they increased it to $5 million. But even though they've increased it to $5 million, you can see at the top, those orange numbers, that's $386 million is the total amount that's ever been raised under Regulation CF. And $100,000 median is the average raise per Regulation CF offering. So not many people have really used it, and they're very, very small deals that are being raised under Regulation CF. And I think the main reason for that is the number one restriction with regulation crowdfunding is the fact that you are required to raise your money to go through a registered crowdfunding portal. And those portals charge fees because they're essentially acting as broker-dealers, securities broker-dealers. So, the few that I've worked on, they charge as high as, 7 to 8% of the capital that you're raising through their platform gets paid to the funding portal. But not only that, I think the main restriction is the fact that in order to get listed on one of these portals, you have to get approved by them first. So these portals are pretty selective with the types of companies that they list. They're selective with, how mature companies are, right? So some of these portals won't accept brand new companies, right? You have to be like an operating for many, many years. But in my opinion, the fact that you have to use one of these funding portals, um, it also means that kind of how many investors you could reach is dependent on the funding portal, because if you get listed on a portal that no one really uses, they don't really have a big investor database, it's going to be that much harder for you to raise money. So you obviously want to be listed on a portal that has the largest reach, the most investors use them, the widest audience. And in my opinion, there's really a top three as far as regulation crowdfunding portals, and the top three are WeFunder, Start Engine, and Republic.co. So if you're interested in doing a Reg CF offering and you want to learn more about the process, my number one advice is talk to one of those three portals. Talk to them about their process, their criteria for getting listed, and see if it's right for you. In my experience, I have not seen a single real estate syndication regulation crowdfunding offering. I haven't seen one yet, and there's probably tons of reasons for that. But I think the one reason is it's just cheaper to do something else, right? Which is, I guess, the last type of offering that I'm going to talk about. Anyways, regulation crowdfunding, it requires the filing of Form C, and there is additional ongoing reporting that you have to do. It's not as expensive and time consuming as Reg A, but the fact that you still have to do ongoing compliance with a max of a $5 million offering, it's not that great of an option for syndicators. So what does that leave you with? Well, let's go back to this picture. So eliminated everything in the right box. What about the things on the left? Offerings exempt from SEC registration. The first option you have is what's known as intra-state offering, which is a Rule 147 offering. And you can kind of guess by its name, it has to be all within a single state. That's what intra-state means, is within a single state. So you have to be from that state. All of your investors have to be from that state. Any LLC that you form has to be in that state. And the property that you're raising money for has to be in that state. So if you're in a state like Texas or California, where there's a lot of investors, a lot of properties, that might be doable. If you're in a state that doesn't have many deals, then you probably wouldn't even be able to entertain that idea. But one of the issues that comes up is, what if you have an investor that says they're from one state, but they're actually from another state, or they say they're from a state and then they use an LLC to invest, and that LLC is actually formed in another state? Well, you just violated the rule. You violated Rule 147, and you've just violated securities law. So in our opinion, it's not recommended to do intrastate offering because of those risks involved. And in our opinion, what should you do? You should probably do a Regulation D offering. So under Regulation D, there's two main types of Reg D offerings. There's 506B and 506C. Let me talk about 506C first. So this also came about from the Jobs Act in 2013. And a lot of people, when they talk about 506C offerings, they use the term crowdfunding because under 506C, you can advertise, right? So I think a lot of people, kind of take that fact that you can advertise, and they want to be able to use the term or the marketing term, we're crowdfunding. So they say they're crowdfunding under 506C. Well, that's not exactly true, because under 506C, there is a limit on who you could take into the deal. So all investors have to be accredited, and you have to verify that everyone is an accredited investor. You have to go an extra step to verify their accredited status. So in my opinion, it's not true crowdfunding, right? Because of the fact that you can't take in everyone. But some people, some people think because you could advertise under 506C offering, it's a form of crowdfunding. That's 506C. 506B is the more traditional syndication. It's the one that, if someone's saying I'm doing a friends and family offering, what they probably mean, there's no such thing as a friends and family exemption. That's not a real exemption, right? What they actually mean is they're doing a 506B offering, and they're only raising money from friends and family because 506B requires that all investors, or that you have to have a pre-existing and substantive relationship with all of your investors. And your friends and family, you obviously have a pre-existing and substantive relationship with all of them. So 506B does not allow advertising, right? So that's the biggest drawback of it. But some of the benefits, there's no cap on how much you could raise. So no limit, like how there is in Reg CF and Reg A. There's no limit on how many accredited investors that you could bring into the deal. And on top of that, you're allowed up to 35 non-accredited but sophisticated investors. So, if your friends and family aren't accredited, they very well could be sophisticated, and if that's the case, then you could bring them into your deal. So, kind of how we advise our clients on which option to choose. If you're a first timer, if you've never done a deal before, then 506B is probably your best option because you're probably going to have to raise money from people that people that are investing in their relationship with you more so than the actual property itself, because you've never done this before. You don't have a track record. You don't have experience. So 506B is probably the best option for you. Once you get a bunch of deals under your belt, then you have a track record, then you could think about maybe doing a 506C offering, because now you're going out and marketing to investors you don't know, and they're going to look at your track record and say, hey, you've done this before. I'm going to invest in your deal. But you're limited to only accredited investors. Well, what's the next step after that? If you have a extensive track record, and you're thinking about doing some sort of fund or blind pool, and you want to raise money from non-accredited investors and accredited investors, well, then Reg A is probably that next step for you. So that's really kind of the process that happens when we're talking with our clients and advising them on which exemption to choose. So that being said, I hope that kind of generated some questions. I'm going to first answer the questions that came in through email, and then I will work my way through the ones that came in through the chat. So first question that came in through email was from Henry. Yes, I would like to find out the costs involved to do a fund formation. Any other costs, services other than the legal side? So fund formation, and let me stop sharing my screen first. So I think what Henry is asking is about, doing some sort of blind pool fund, costs involved in doing that. So I will say securities costs. So, our law firm, our fees typically range between $10,000 to $20,000. If you want a specific quote about, your fund and your deal, feel free to reach out to me directly, and I will give you a specific quote for your offering. Any other costs associated? So every LLC that we form, there's filing fees for that. There's yearly fees for the LLC. You probably need a registered agent. There's a yearly cost for that. You're probably gonna have to hire a CPA. So think about accounting costs. And then because you're doing a blind pool offering, so to kind of explain what that is for the people that don't know, you're raising money blind, so you don't have a specific deal identified under contract. Your plan is to go out and buy multiple deals after you've raised money. Well, if you're doing that, you likely have to form a new LLC for every single deal that you acquire, because there's a whole host of reasons why you need to separate assets into different LLCs, but you'll find that if you're getting loans on these properties, lenders will require it. So every property needs to be in its separate SPE, a special purpose entity, or single asset entity is another term they use. But because of that, there's additional LLC costs involved when you're doing a fund, right? So there's more startup costs, there's more filing fees, state filing fees. Other than that, you will probably also have to pay. So when we do a 506B offering or 506C offering, any Regulation D offering, you have to pay filing fees to the SEC and state notice filing fees. There's every state charges a fee to raise money from, essentially. Overall, I think our clients on average pay about $2,000 to $3,000 for those fees. What else? Investor relations, you got to think about that, right? Are you doing it all yourself, or are you going to be using some sort of third-party platform to deal with your investors, to do kind of the back end stuff and the accounting stuff? But yeah, those are the main costs and fees that I can think of. Okay, next question. So there was a question about Reg CF, and I think I covered that, but if anyone wants me to clarify more about Reg CF, I could do so. Question about fund of funds. Okay. Overview of fund of funds. Appears to be a hot topic right now from Kevin. So fund of funds. All right. So, imagine a blind pool, right? But instead of the blind pool, the purpose of the blind pool is to go out and buy a bunch of properties. Imagine a blind pool that its purpose is to invest in other blind pools, right? So that's essentially what a fund of funds is. You are forming a fund to invest in other people's deals, other people's syndications. Yes, it's very popular right now. I think because of where the market is and how few deals there are right now, a lot of people are kind of entertaining this idea of forming fund of funds to deploy capital faster. I mean, that's the benefit of it. And the number one reason why you would want to do a fund of funds is you have more options, and it's faster to deploy capital. There are a ton of issues with doing a fund of funds, both for the underlying fund, right? So the fund that's going out and actually investing and buying property, and specific to the fund of funds. So let's talk about the first one first, right? If you're a syndicator and you're thinking about accepting fund of funds money, some of the issues that you need to think about are what type of offering are you doing? So are you doing a 506B or a 506C? If you're doing a 506B, then do you have a pre-existing and substantive relationship with the fund manager? And number two, does the fund of funds qualify as either sophisticated or accredited? Well, sophistication, you would look at the fund of funds manager, the fund manager, to see their level of sophistication. Accreditation, though, however, is a little bit trickier because you're looking at this entity, and how does an entity qualify as accredited? Well, two ways. One, either the entity holds over $5 million in assets and wasn't formed for this specific investment. Well, that's relatively easy to figure out, right? So you just look at the fund of funds balance sheet and you see, if they have over $5 million in assets, then you could say, oh, this entity is accredited. If that's not the case, then the only other way that it could be accredited is if every single beneficial owner, every investor within the fund of funds was accredited themselves in a different way. So either through the income or net worth threshold, which is, difficult to verify, could be difficult to verify. But if you're doing a 506B, you don't need to verify it, right? There isn't that requirement that you verify. If you're doing a 506C, however, now you have to go through that process of verifying that the fund of funds is accredited. And if it's the latter category, and all investors are either accredited through income or net worth, does that mean you have to verify every single individual investor within the fund of funds? That's one option. We usually recommend just hiring a third party to do the verification for you, so you don't have to worry about looking at every single investor's tax returns and income statements. So that's the underlying syndication, the underlying blind pool. What about issues for the fund of funds? Well, one of the things that people don't really know about and don't really consider is what's known as the Investment Company Act. which governs investment companies. And an investment company is a company that is in the business of buying and selling securities. And if you are forming a fund of funds, you're not in the business of real estate anymore, right? You're in the business of buying other people's securities. And if that's the case, then you either have to register as an investment company with the SEC, or you have to find some sort of exemption that you apply under. So it's an additional exemption that you have to figure out besides the SEC or the Regulation D exemption. You need to find a Investment Company Act exemption. And the easiest one that I know of is the small investment company exemption, which is if you have fewer than 100 investors, then you are exempt from registration as an investment company. So if you're thinking about doing a fund of funds, that's probably my recommendation, is just make sure that it's smaller so that you allow fewer than 100 investors. There's other issues involved, so I don't want to go too in depth about fund of funds. But if you have more questions about it, feel free to reach out and we could set up a call. Next question from Bao. I guess he created some sort of tool to apply AI and file patents. We were thinking about allowing the users to create landing pages and crowdfund based on the patent application, similar to Kickstarter. So my answer to you, Bao, what other potential legal issues do I anticipate is, number one, I'm not a patent attorney, so I can't really speak to any of those issues. But from a crowdfunding and securities and syndication issue, how are you being compensated, right? So if your plan is to create some sort of platform for other people to raise money, and you are charging them fees based on how much money they're raising, the SEC considers that transaction-based compensation. And if you are doing that without being a licensed securities broker dealer, that is not allowed. So basically what I'm trying to say is you need to be careful on how you're compensated if you're thinking about forming one of these platforms. If you're providing essentially software, that's the service you're providing, and you're being paid like a flat fee or a monthly fee or a subscription, then that's probably fine, right? You're not helping people to sell securities and receiving a commission to sell their securities. But if you are charging fees based on how much they're raising money, probably don't do that. So next question. Okay, so those are all the outstanding email questions. Let me go through the ones that came in while I was talking earlier. So first question from Scott: if you only have one passive investor, is it still considered a security? Great question, Scott. Let me pull up that slide again. Hold on. Where is it? So if you have a single investor, do you still meet all four factors of the Howey test? Well, one, yes, there is a investment of money. Is it a common enterprise? I think this is what this prong is what that question goes to, because you still have an expectation of profit, right? The single passive investor wants to make money on their investment, and they're still the promoter, right? You're the one doing all the work to realize the profit on their behalf. But is it a common enterprise? Well, if it's only that one investor putting in money into the deal and you're not doing anything, you're not putting any money, no other investor is, then my argument, and you could argue, that there's no common enterprise, right? There's only a single investor. However, if you are also putting money into the deal as the promoter, and the courts are actually split on this, right? So it's what's known as vertical commonality versus horizontal commonality. So horizontal commonality is, multiple investors, multiple passive investors. That's what's required. Vertical commonality is if there's a single investor and the promoter is also putting money into the deal, is that a common enterprise as well? The courts are split on it. So some courts believe, yes, that still counts as a security because there is a common enterprise with the single investor and the promoter. My recommendation, I don't off the top of my head know, what courts are split on this and where, the split is happening. So I can't advise you on, if you're in this state, does that apply to you? My recommendation is if you are putting money into the deal with a single investor, then you are probably selling a security as well. And just to be safe, you should find some sort of exemption and follow all the rules in that case. So answer that one. Next one. How do you connect with Gene? So are you asking how I connect with Gene or how you connect with Gene? Because how I connect with Gene is my partner at this law firm. So Trowbridge Nieh Law Group. Gene is Gene Trowbridge. I'm Jon Nieh. So we're the two founding partners of this law firm. How did you connect with Gene? Well, you could go to our website. We both offer free consultations there, and you can schedule a consultation with Gene on our website, or you can email him. His email is gene@tnllp.com. Chris asks, what is the minimum size of capital raise makes sense financially when considering the legal fees? So, I mean, that's going to depend on everyone's specific deals. Speaking from my personal experience, anecdotal experience, I've helped clients raise as little as a few $100,000. Most of our clients, though, are raising over $1 million. I would say the vast majority of our clients are raising upwards of $5 million. But again, legal and accounting and all those costs, upfront costs, expect to spend maybe $10,000 to $20,000 for each deal. And then you need to figure out on your own, the expenses of your deal. Does that make sense for the deal that you're doing? Chris again asks, so does the operating agreement have to say unanimous decisions? Can't it be based on a minimum percentage of equity, say 75%? So I think this question came in when I was talking about, having a member managed LLC. And if that's the case, then you're not selling securities, right? So I should clarify, right? So it's, it doesn't, I don't want to say it doesn't matter, but you could conceivably think of a situation where there's like 3 members of an LLC and it's member managed, but one member owns 98% of the LLC and the other 2 members own 1% each. And essentially this one member, outvotes the other 2, right? Any decision requires majority approval, and this one member, because they own 98%, they can make all the decisions. If that is the case, then I would argue you're still selling securities, even though it's member managed, because of the fact that one person has exclusive authority to make decisions. So it doesn't necessarily have to be unanimous, right? So the operating room can say, it requires majority approval. It requires 75% approval. But when you look at the actual, I guess, decision making and how it actually shakes out, if it's designed so that a single person or a single entity effectively makes all of the decisions, and you have multiple investors in the deal that don't have that authority, you are probably selling securities, and you now need to either register your securities or find an exemption. Okay, Nicole asks, what is the limit of private money lenders I can have on one property deal in order to stay in compliance with securities laws? For example, if I am fix and flipping a house with 2+ private money lenders and a traditional lender in first position, do I need to syndicate? So I think your question is really, are you selling securities, right? If your deal involves 2 private money lenders and these private money lenders are investors in your deal and don't have any decision-making authority, then yes, you are selling securities. And if that's the case, you need to structure your deal to protect you, and you need to, pick some sort of offering exemption to apply under. If you have a single private money lender and you're not putting any of your own money into the deal, and they're the only investor in that deal, then you could make the argument that you're not selling securities because there's no common enterprise at that point, right? Jason, hey, how's it going? Can you please do a quick, simple overview of how tax treatment flows through to the members of the LLC? So I will try my best. Again, I'm not a CPA, I'm not a tax attorney, but from my understanding, an LLC, you can choose to be taxed as a partnership as an LLC. So what that means is an LLC, there's no double taxation if you choose to be taxed as a partnership. So all the taxes flow through to the underlying partners, or in the case of an LLC, the underlying members. That is, I think that's what you're kind of alluding to, is the fact that any taxes that are owed, or any tax benefits that are conferred from the property, get passed through to your underlying investors. So depreciation, any other tax advantages of investing in real estate, all of that gets to flow through to your investors. And so that's why a lot of people, that's what I believe, or I think why a lot of people like using LLCs for real estate, is because of that tax flow through element of it. So I'll ask, your firm has raised over, so I need to clarify, our firm has not raised over $6 billion. We don't raise money for our clients. What we do is we set up the deal, and we guide our clients on which exemption to use, and then we also file any documents and make sure that our clients are raising money in compliance with those rules. So our clients have raised over $6 billion, and I guess indirectly we've helped them because we've set up their entities and restructured their deals and we drafted their documents. But we do not raise money for anybody. We're a law firm, we're not brokers, so we don't do that. Hi, John. I am in the state of Florida. I am new in real estate broker. Can you assist for newbie? Sure, Jim. I can try to help you as best I can. Feel free to reach out to me whenever you get a chance, and I'll try. Do we need to set up the manager LLC even for IRO deals with 2 or 3 partners? So IRO, for those that don't know, is independent. I think independent real estate. What does the R stand for? I forget, but it's basically you're not syndicating, right? You own the properties outright. Essentially, is an IRO deal. I think it depends. I mean, if you have 2 to 3 partners, and you need some sort of entity to manage the deal on behalf of everyone, then I think you should still have a manager LLC. I don't want to get too into the weeds with this answer, but every deal is different. Yeah, I'll just leave it at that. I mean, if you have specific questions about a specific deal that you're trying to do, you should probably reach out to us separately, and that way we could have a confidential discussion, right? We could establish some sort of attorney-client relationship, and I could give you actual legal advice about your deal. Yeah. Henry asks, funds I see mostly are real estate based. Is a fund for mortgage lending possible? Yes, great question. You could do a fund for anything, right? So you could do a blind pool to do mortgage lending, right? That's what we call a debt-based fund, right? You're doing a fund to originate loans. You could do a fund to buy underperforming notes. You could do a fund to some people call it a rescue fund, to inject new capital into bad deals. You could do a fund for anything. There's no restriction on types of funds. You could be as creative as you want. Scott says, assuming $1 million capital raise, what fund structure do you suggest for someone's first raise? So I think I answered this earlier. If it's your first deal, we typically recommend doing a 506B offering because you're going to be raising money from your friends and family anyways. And that's the easiest way to do it is 506B. What is the difference between a customizable fund and a syndication? What are the fees for a customizable fund? So I'm not exactly sure what you mean by customizable fund, but I guess the difference between a fund and a syndication, well, I mean, syndication, I guess, implies that you're doing a specific property or specific deal. It doesn't, I don't think that's a requirement. I mean, syndication just means you're raising money, right? You're syndicating from multiple investors. Excuse me. But a fund kind of implies that there's this blind element to it, right? That you're doing something not specific. Fees, I think I kind of alluded to the fact that doing a fund can cost a little bit more because you're probably forming more LLCs. But as far as legal costs, like our legal costs, there really is no difference between doing a fund and a specific offering. Our legal costs are typically about the same. What is the minimum NOI that I, as an LLC manager, should be targeting for my first syndication to make it a profitable venture, given averages based on your experience? I understand every deal will be unique, just looking for a safe average. So I'm not exactly sure NOI, a good NOI to hit for your first deal, but I will say, getting an IRR of about 15 to 20% is probably pretty good. I'm not I'm an attorney. I'm not like a financial analyst. I'm not I don't like review markets and stuff like that every day, right? So I might not be the best person to kind of give you that answer. Talk to investors, right? See what investors are looking for. Talk to the people that you're going to be raising money from and be like, hey, like, what are you looking for? What's a good NOI target for you if I were to do a deal? And there, you got your answer right there. Okay, Chris, you're asking how I and Gene met. So Gene and I met. So when I was in law school, I did an internship at this company called Patch of Land. And this is one of those companies that was doing 506C offerings and calling it real estate crowdfunding. But anyways, Patch of Land, they had hired Gene's firm at the time to do some work for them. And then when I graduated law school, my boss, the general counsel of Patch of Land, she introduced me to Gene. And he kind of hired me after law school, and I've been working with him ever since. So that was about 8 years ago. Now we're partners, and now we have this firm together, which has been great. So yeah, that's how I met Gene. I know you were talking from the syndicator side, but what does recourse look like from the LP side? Okay, so Barry, this is going to depend on the operating agreement, right? So if we're talking about LLCs, then the LLC operating agreement governs everything. It governs how the company is run. Government governs how you as an investor can get out of the deal, right? So liquidity, how you can maybe remove the manager for doing something wrong. Do you have to go through mandatory arbitration? Can you sue them? Your recourse and how you're protected is governed by the operating agreement. So every deal is different because every deal has a different operating agreement. If you're an actual LP and there's a limited partnership, then you have to look at the partnership agreement. But yeah, I mean, I can't really answer that for a specific deal unless I read what the operating agreement says. Gene Trowbridge is the most honest, experienced investor and great lawyer. Most importantly, excellent friend to have. Yes, I definitely agree with that statement. Thank you. Barry, asks, let me be more specific. As an LP, the OA does provide for replacement of management for cause, but now how does this affect the decision making if the supermajority vote does decide to replace the managing member? So again, everything needs to be handled according to the operating agreement. So, I'll just give you an example, right? So if there is cause to remove the manager and it says you need 75% vote approval to remove the manager, then usually, you have to send some sort of notice to the manager to cure whatever you believe he's doing wrong. If some time passes, whatever is laid out in the agreement passes that they haven't cured it, then you could proceed with actual removal. And then there should be a provision that talks about replacing the manager, like what vote you need to elect a new manager should also be in place. But yeah, I mean, you need to read the operating agreement is the answer to your question, Barry. Adam asks, are there any regulatory accounting audits that should be expected? SEC accounting audits, or maybe agencies that might do accounting audits. So the SEC would never do an accounting audit. I mean, that's going to be the IRS. Should they be expected? I don't believe so. I don't, from my own experience, I've never had a client audited by the IRS. If you want to know what are your chances of getting audited, I think you should talk to your CPA. From my understanding, the risk of being audited are relatively low, especially right now because the IRS is underfunded. Unless you do some sort of amended tax return. If you amend your tax return at some later date to correct something, apparently, and this is what I heard, so I don't know if this is true or not, but apparently that is a giant red flag, and that could be a cause for actually getting audited in the future. But again, talk to your CPA. They know way better than I do. Okay. Someone sent me a thing about customizable funds. Yeah, tell you what, let me review this website, and then if you want, you can schedule a call with me and we could discuss my thoughts on it. But yeah, it looks like that was the last question. Let me hold on. Let me pull up our contact info so that you guys could all have it. Hold on. Here we go. Okay. So if you guys want to contact us, here is our main number. I think the best way, though, is just go to our website, tnllp.com, and you could schedule a free consultation with myself or Gene. We also have a YouTube channel. So Gene and I, we make YouTube videos, a lot of videos, it's free, right? Free content, free information, a lot of great information on our YouTube page. But I had a great time doing this. I think it was a lot of fun, a lot of great questions. And tell you what, I mean, why don't you guys send us an email and tell us what you guys thought, if you enjoyed it. Should we do another one? I was thinking maybe doing one a month just to answer any questions that come up. But it's really up to you guys. I mean, if we have a good response about this, then yes, we'll definitely do another one. But other than that, thank you all for joining. Really appreciate all the great questions and for you guys hanging out with me for the last hour. But again, there's our contact info if you guys want to reach out and want to get more information from us. But yeah, thank you all. Hope you guys enjoy the rest of your week.